Today, we will once again revisit the top mistakes that well intentioned but under-informed entrepreneurs and business owners commit when attempting to move their business to a new state without the assistance of a competent attorney. Business owners often mistakenly assume that moving their existing company from one state to a new state is just a matter of filling out a few forms online. That is false. And that false sense of simplicity is the single biggest cause of corporate death during a redomestication attempt. The Secretary of State does not tell you what documents to file, how to prepare them, or how to protect yourself from tax and legal fallout. The IRS certainly will not warn you before it sends you a five-figure or larger bill for getting it wrong. Every month, our firm receives panicked calls from business owners who thought the DIY approach would work. It did not, and they ended up dismantling their company overnight and by accident. In this video, we will discuss the 6 most common and most devastating mistakes business owners make in this process and why each one can potentially be fatal to your business. My name is Chad Cummings, and I am an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the law firm Cummings and Cummings Law. I also teach business law at the university level, and I hold 4 degrees, including 2 law degrees, together with a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. My firm website is www.cummings.law. Many years ago, author Michael E. Gerber wrote a book entitled The E-Myth: Why Small Businesses Don't Work and What to Do About It. The entire book is well worth your time and consideration, but for purposes of today's presentation, I will emphasize a single aspect, which is perhaps the most important takeaway. The reason that most small businesses fail is that the business owners, who are accustomed to having to do everything by themselves all the time, make the false assumption that just because they know how to sell their particular good or particular service, they are experts in everything else too. Legal, tax, you name it. That's simply not the case. The mark of a true credentialed professional is that they will tell you candidly what they know and with equal candor what it is they don't know. I have met many intelligent, capable, impressive, small and medium-sized business owners who are lulled by this so-called E-myth, thinking that they could spend 15 minutes on Google, Reddit, and ChatGPT, and they would magically somehow know the law. Unfortunately, by the time these individuals find their way to our law firm, more often than not, they've taken the scattershot approach by filing a variety of documents with the secretaries of state based upon their own research. And they only come to us once they're getting angry letters from the IRS, the secretaries of state, their creditors, and their customers, often after they have inadvertently dissolved their company. Sometimes we can help. Often we cannot. When we can help, the process usually costs, and I am not embellishing here, 10 to 15 times as much money as if my firm had simply been hired out the outset, and it takes 6 months to resolve or longer instead of 4 to 6 weeks. I am aware of one individual who shall remain nameless who tried to handle things on their own and lost, and again, I'm not exaggerating here, over $13 million in the process. They also lost their house, their retirement fund. Needless to say, they can no longer retire, and their spouse is not very happy with them. I'm not exaggerating when I say that had this person spent even 20 minutes on the phone with me at the outset and hired my firm instead of taking the law into their own hands, that outcome was 100% avoidable. I tell would-be do-it-yourself clients that practicing law on yourself is a bit like performing brain surgery on yourself. Even if it is theoretically possible, you will probably not like the outcome. With all of that in mind, I will now cover some of the most common and fatal mistakes business owners commit when attempting to move their existing company to a new jurisdiction without the help of a licensed attorney. If you would like to dive deeper on any of these topics, please reference my earlier videos or schedule time to speak with me using the information contained at the end of this presentation. The single most expensive mistake is treating redomestication like a dissolution. It is not a dissolution, and those terms cannot be used interchangeably. Business owners who file new articles of organization or incorporation without preparing and executing the legally required plan of conversion together with the articles of conversion or articles of domestication have not moved their company. They have created a brand new duplicate zombie entity. The IRS interprets this as the old company being liquidated and a new company being formed. That means that all of the assets of the old company are distributed to the owners and recontributed to the new entity. If those assets have appreciated value, for example, real estate, goodwill, or even equipment, this triggers taxable gain at both the federal and often state levels. Some owners receive IRS notices for tens of thousands and sometimes hundreds of thousands of dollars of phantom income from what they thought was a harmless address change. Once this happens, the IRS will not reverse the treatment. Redomestication done properly avoids any taxable event. Let me say that again for the people in the back. Redomestication, when handled by a competent licensed attorney, avoids any tax bill. Done improperly, it becomes a de facto liquidation. Number two, accidentally dissolving the company and losing all legal rights. This is a big one. Another catastrophic error occurs when business owners file dissolution paperwork in their home state before filing the domestication articles in their new state. Dissolution terminates the legal existence of the company. The moment that filing is accepted, your business ceases to exist, along with its federal employer identification number, contracts with both vendors and employees, as well as customers, licenses, and corporate identity. You cannot, in many cases, later revive it because there's nothing left to convert. And when it is possible, it is expensive and time-consuming to do so. Vendors, banks, and even the IRS will treat the company as defunct. Clients often learn this the hard way when their merchant processor freezes their account, their bank closes their account, or their insurance carrier cancels coverage. Worse, some business owners discover that by dissolving the entity, they avoided all of their contracts, terminated their employees, and forfeited intellectual property rights. A proper redomestication preserves the continuous, uninterrupted legal identity of the business. A dissolution destroys it. Number three, filing incomplete or inconsistent documents that get rejected or void the conversion altogether. Many DIY business owners use random templates they find online or which were generated by ChatGPT, not realizing that every state has its own statutory and, in some cases, common law requirements for handling this complicated and nuanced legal process. Florida, as well as Texas, both require the preparation and execution of what is known as a plan of conversion, together with articles of conversion and articles of organization or incorporation, each containing very specific language dictated by statute. Most other states require reciprocal filings with different terminology. If these documents are inconsistent, missing signatures, or filed with the wrong filing costs or in the wrong order, the Secretary of State may reject them, and the rejection may not happen for several weeks and in some cases months, by which time the owner will have already dissolved the original entity, opened new bank accounts, and changed contracts. The result is a legal black hole where the business exists in neither state and the business owner subsumes personal and unlimited liability for every obligation of the business. Hello, bankruptcy court. Once that happens, the only way to fix it is to start over from scratch, often at enormous cost. Proper legal preparation prevents this nightmare scenario. How about number four, losing the company's employer identification number, bank accounts, and credit history? When a redomestication is botched, the Federal Internal Revenue Service often interprets the transaction as the death of one entity and the birth of another, a zombie. The old federal employer identification number is terminated, forcing the owner to apply for a new one, and no, you cannot get it back in most cases. The consequences are severe. Payroll accounts, 1099 reporting, and banking relationships associated with the former employer identification number immediately break. Merchant processors may suspend deposits. I've seen that happen more than once. Business credit bureaus like Dun & Bradstreet erase years of payment and credit history. Lenders and insurance carriers treat the new company as an unproven applicant with no track record. In extreme cases, the IRS assigns the same EIN to a new taxpayer after 18 months. Think about that disastrous scenario, permanently severing your audit trail. Once you lose your EIN continuity, your business identity is effectively reset to zero. A properly executed redomestication preserves your federal employer identification number seamlessly, avoiding these sometimes irreversible disruptions. Number five, violating state law and exposing yourself to civil and, in extreme cases, criminal liability. Every state has strict statutes governing how a foreign entity may relocate, convert, merge, or redomesticate. And by the way, those are all different things. If you don't know that, check out my earlier videos describing the differences between those processes and redomestication. Filing false, incomplete, or misleading documents with the Secretary of State can constitute a third-degree felony. Many business owners inadvertently make false statements when they self-file because they simply do not realize that each document must reference a specific statutory authority and formal adoption procedure. Some even sign under penalty of perjury without having executed the requisite plan of conversion or written consent of members. This is not an administrative oopsie. It is a criminal offense in some cases. Even if prosecution is unlikely, the filing will be legally defective, leaving the company and its owners vulnerable to significant time-consuming and expensive challenges in court at a later date. A licensed attorney knows precisely how to structure and execute each step to maintain conformity and compliance with state law and to avoid personal liability. And number six, last but not least, destroying contracts, licenses, and liability protection. The most overlooked mistake in this context made by small and medium-sized business owners moving their company to a new jurisdiction is failing to appreciate and understand how redomestication interacts with contracts and regulatory filings. When a business owner files new formation documents in the new state without completing a valid conversion, the resulting entity is not the same legal entity as before, even if they have the same name. That means that it is not a party to your existing contract. Stop and think about that for a minute. It is not a party to your existing contracts. Vendors, landlords, and customers may demand new agreements, probably on less favorable terms, or treat the old ones as void. State licensing boards, especially for contractors, professionals, and healthcare providers, may require a reapplication under the new entity. Insurance carriers likely terminate or in some cases rewrite policies. Even worse, because the old entity was effectively dissolved, any claims or lawsuits pending against it may now be redirected personally against the owner. As I said before, hello, bankruptcy court. Your liability shield disappears. Redomestication, when performed correctly, maintains perfect continuity of your entity, ensuring all contracts, licenses, and protections remain intact. Here's the bottom line. Trying to redomesticate your business without an attorney is not a smart money-saving shortcut. It is a legal minefield that can obliterate your company's continuity, finances, and credibility, as well as your personal credibility. Once you have triggered an IRS taxable event, dissolved your entity, or lost your federal employee identification number, there is no quick fix. The cost of so-called cleanup work routinely exceeds $10,000, actually quite a bit more than that, and in some cases cannot be undone at all. Redomestication is a precise legal process that requires careful sequencing, statutory compliance, and tax awareness. That's not something you're going to find in an online template or ChatGPT. If your business matters to you, why would you gamble with its legal existence? Engage a licensed attorney and CPA who understands both the legal and tax domains of redomestication, thereby preserving your contracts, your federal employer identification number, and your liability shield. The small amount of money you might save by avoiding professional help will not cover the cost of rebuilding what you lose when you try to do this yourself. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this video is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding the content of this presentation or of any of my earlier presentations, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.